In 2012, Leein Hinkley was convicted on charges related to stabbing his girlfriend and one other person. He was sentenced to prison and released early in 2023 on probation. Hinkley was still on probation when he was arrested in May, accused of domestic violence. And despite prosecutors' pleas to hold him behind bars, he was granted bail and released. 3 days after that, he was killed in a shootout with police in Auburn. And now the judge at the center of this case is coming under fire. Pearl Small joining us live in the studio with more. Pearl.
Yeah, Brian, it was that judge's decision that ultimately led to Hinkley's release. The action was criticized earlier this week by unions representing police departments, and today Governor Janet Mills is joining those who question the judge's decision. Jonathan Sarbeck is a former district attorney who spent plenty of time trying to persuade judges to rule in his favor, and he says this case is about more than one defendant.
Basically protect public safety, but also protect the rights of the accused.
According to former Cumberland County District Attorney Jonathan Sarbeck, those are the two main responsibilities that fall on a judge's shoulders.
So it's always a balancing test on what that judge can and cannot do.
Governor Janet Mills is now accusing Judge Sarah Churchill of failing to live up to that responsibility when she made a ruling in Leein Hinkley's probation hearing.
You had the district attorney in Androscoggin County begging the judge, do not release this man out into public. He's a danger.
But Hinkley's bail was reduced and he was released. 3 days later, he allegedly went to his ex-girlfriend's home in Auburn, bringing a gun and starting a fight with a man inside the home. The man was later found dead inside the home after it burned to the ground. Hinkley led police on a chase, shooting at them, before he was shot and killed by officers.
This is a case that never should have happened.
There were no public defenders available to represent Hinkley, leading Judge Churchill to lift his probation hold and lower his bail. Churchill said the lack of a defense attorney violated Hinkley's Sixth Amendment rights, also saying she didn't believe she had the authority to appoint a lawyer for Hinkley herself under Maine law.
In my past, judges have been able to appoint attorneys, even if they might not be on the list at that current time.
Governor Mills said given the severity of this case, that's exactly what Churchill should have done, stating, while Maine law states that the Maine Commission on Public Defense Services is responsible for providing counsel for indigent defendants, there is nothing from prohibiting the court from appointing counsel for defendants themselves.
I can tell you it's very rare that you would have a judge just straight up either dismiss a case or lower cash bail or lift probation holds because of the lack of available attorneys.
Sarbeck says this case is highlighting much bigger problems in Maine's legal system.
Right now, Maine is facing a crisis when it comes to a lack of attorneys who are making themselves available for public defense, and that is obviously having repercussions in the court system.
Now, Governor Mills did address the lack of public defenders in her statement. Mills said she will be meeting with the chair of the Maine Commission on Public Defense Services to consider what more can be done to improve this issue and ensure that an incident like this never happens again. And earlier this week, the Maine Judicial Branch sent us a statement agreeing with Judge Churchill's assessment that not providing defense counsel for Hinkley violated his constitutional rights. Brian?
Pearl Small live in our studio tonight. Pearl, thank you.